have with us this morning Ofyong, who is a senior advocate of Nigeria. You're welcome to Sunrise Daily this morning.
Thank you for having me.
Well, you saw the strong words. We understand that the Justice Ogi delivered her judgment in an emotion-laden voice. It means that she was really pained delivering this judgment. But you have seen how the dailies have reflected it. What were your thoughts when you heard the judgment as delivered by Justice Ogi yesterday?
Well, let me segment or disambulate two things. Number one is the emotional delivery by His Lordship, and then the other one is my reaction to the judgment. The lordships are used to being very measured. So I wasn't in the court when this was delivered. So I'd like to presume that the lordships were not emotional. They were passionate in the sense that the fidelity to the rule of law is never to be taken for granted or doubted at any time. So they reaffirmed that principle that the judgment of the Supreme Court is final. And although there is a very narrow window through which a review or setting aside could be done in the interest of justice, that was not obtainable in the case before them. Then my reaction to the judgment, relief, to be honest with you, because as the Supreme Court themselves had noted way back in, I believe, 1986, in the Adigun case, that once you don't hold a strict limit to litigants coming back to the court, then you throw the whole principle of the finality of the judgment of the Supreme Court into disarray. Therefore, and it could be seen, at least from the comments in the press, that once Imo went, Bayelsa went, and Zamfara went, and then you had an avalanche of everybody is even threats that they were going back for review of the presidential election. So it raised a very frightening specter for the rule of law, for the finality of judgments of the Supreme Court. So hearing the Supreme Court reaffirm what they've always said about the finality of the judgments was quite a relief to me, I must confess. That's not to ignore the fact that the Supreme Court themselves have also recognized that in appropriate cases, you can actually apply to set aside the judgment, and they've articulated that in very many of the cases. There's a fraud, there's a practice of deceit on the court, there's a nullity, and so on and so forth. So those are instances where they said, yes, if any of this comes up, we will be able to set aside such a judgment or review it, but it's not a general, it's not an all-common affair.
Those cases have been few and far between.
Very few and far between. And even what we saw in the imposition of sanctions, because that's what the punitive cost.
I was just about to come there now.
Yes, okay.
Yeah, what you made of that? Because some people have said, is it a matter of procedure or was it punitive on the lawyers?
It's punitive. It's actually punitive. It's meant to discourage lawyers who are the gateway, bringing those applications before the court, to say to them, look, you should be able to spare us this because you are knowledgeable, you're learned people, you know what our position is over this matter. So you shouldn't come to us with this kind of thing. If they think that this was frivolous, and they've done that in the past, so they impose punitive cost. And in addition, make counsel pay that cost. That's a way of putting every professional. I mean, I can't imagine going to the court, and thank God for the caliber of counsel who were involved in it. I can't imagine going to court to make an application for a client that I was expecting to earn some money, and I end up losing 10 million. That is alarming.
Is it?
Yeah, okay, yeah, okay.
I mean, some people have looked at the caliber of lawyers
I don't know how many clients they represented, because the cost was awarded in favor of each of the clients. So if I'm representing one of the clients, then the cost against that client would be 30 million. But if I have two of them, for instance, and cost is awarded for each of them, then, okay, actually cost is awarded against each of the parties. So if you award cost against each of two parties that I represent, that comes down to 20 million for only
no, they
my
had
clients.
to pay 10 million to each of the respondents.
Sure. Sure,
so, I mean, so it meant that even if representing just one party, you had to pay every of the respondents joined in the case. Wasn't that the matter?
Sure, that's what it means.
Okay. Well, so with benefit of hindsight, because of course they always say hindsight is, you know, it's 20/20 vision.
Yes.
Would you say, I mean, because some people have also, expressed a bit of disappointment with the caliber of lawyers who actually took that matter up for review. Did you have any of such reservations when you saw the caliber of lawyers who took up the matter for review?
Okay, I take your position first, the 2020 hindsight.
Yes.
When the Supreme Court makes a pronouncement, not only are they final, but except for academic discourse, they're right. You can't change that. Of course, it's allowed for academicians to criticize the Supreme and so on. But what was I disappointed at the... sorry, I need to put it this way. Because the Supreme Court has made this pronouncement, and I was not counsel in the case, I do not know all of the facts in the case. Looking at it from the prism of the 2020 hindsight, yes, I'm disappointed that the Supreme Court, this was an application taken by the caliber of counsel involved and who have received this kind of strictures from the Supreme Court. And the Supreme Court must be right. Counsel cannot be right against the Supreme Court. So that's one part of it. The other part of it is to also plead that it's always a difficult call for counsel to make this judgment, with this decision, particularly in an area where there has not been clearly laid down precedents of the court. Have we had the Supreme Court make pronouncement clearly on fundamental breach of fundamental rights as a basis for saying the judgment is a nullity? Yes, we have had that. Okay? I've tried to look at some of the arguments involved. The only narrow thing I could see is that because the Supreme Court, a number of the points which could apply to the lower courts will not apply in the Supreme Court. And let me explain that very briefly. It's like this. The Supreme Court is the only court which is allowed to determine an appeal upon just a sole issue. In other words, you can raise about 9 issues for determination by the Supreme Court. The lower courts are enjoined to determine all 9 issues or give an explanation why the 9 issues were not determined. Otherwise, that's a breach of fundamental right. But for the Supreme Court can nominate only one of the 9 issues and determine it on that basis. And because it's the Supreme Court, that will not be taken as a denial of right to fair hearing. That again has been determined as a matter of principle. The other thing is that sometimes in determining that one sole issue, even without rephrasing the other issues, the Supreme Court may subsume in that one issue some of the points which had been canvassed in the other issues. So if an issue had been subsumed in the one issue determined, again, you cannot say that this is a matter which breaches the fundamental right. But bottom line is, unless you... the Supreme Court has made a determination now that this application, which was brought by Bayelsa, the candidates of APC and the deputy governorship candidates, as well as the APC as a political party, had no merit in it. And once the Supreme Court had made that pronouncement, whether we agree with it or not, we must abide by it. So I have some sympathy for the counsel who took the application before, because it's a difficult call to make.
Let's quickly look at some of the pronouncements made by the Supreme Court. I think you were showing earlier on your screen, if you can quickly pop up again. But some of them quickly read. The court is not authorized and indeed lacks jurisdiction to review any judgment delivered on merit, more so when the applicants have not pointed out any accidental error or slip in the judgment. There must be an end to every litigation. There's also the fear, this is a fear expressed by the Supreme Court, even if we review this judgment, every disaffected litigant will bring a similar application and the finality of the Supreme Court will be lost. This court is the final court of the land and its decisions are final for all ages so as to ensure certainty in law. Some people interpret this to mean that it has implications for the rest of the reviews which have been brought before the Supreme Court. Do you agree with them?
Well, unless I know all of the facts surrounding the other reviews, I wouldn't be able to say I agree or I don't agree with them. And I need to say this, you know, the Supreme Court operates a principle, the courts operate a principle we call stare decisis, the binding precedents. Now, and the precedents only apply where the facts are similar or identical. If the facts are not similar or identical, then the principle stated in one case is not applicable to, okay, that's a principle we call distinction. Now, so I would need to know what are the facts applicable in all of the cases before I can make that call. Unfortunately, I'm not in a position to say whether one affects it. But I can state this as a matter of general principle. What the Supreme Court has said there is a reaffirmation of Section 235 of the Constitution, namely that the judgment of the Supreme Court is final, except for the exercise of prerogative of mercy by the president, or in the case of a state matter, the governor, the judgment is final. So, again, the Supreme Court has written into its rules, I think Order 8 Rule 16, that there is also a very limited window for reviewing any of his cases, if there's a clerical error or but where the judgment represents the substance of the decision of the Supreme Court, they can only make a review in order to bring the judgments in line, or bring the reliefs in line with the substance of the judgment. So again, it's a very narrow area. The other point is that the Supreme Court themselves had recognized, and I don't think this judgment changes that where a judgment is obtained by way of fraud, by way of deceit, practiced either on the court or on the party, and a number of other situations, and the Supreme Court in the past has reviewed its judgment on those bases. But it's a very narrow principle. So the general principle which the Supreme Court has restated in this case remains very correct. Supreme Court judgment is final for all. That's why they say we are not final because we are infallible. They recognize that, yes, we can make mistakes, but we are infallible because we are final. So once you deny that finality, then you open the Supreme Court to everyone coming to point out how infallible or how fallible they are. So it was necessary to keep the lead that this is the final judgment. Every litigant should rest.
Let's go to Lagos now and take some questions from my colleagues.
Well, Mr. Fion, from what, you know about this particular review, the decision of the Supreme Court, do you think that this principle in generality will also apply to not just the cases that are before the Supreme Court in seeking review now, but subsequent cases? Does that mean that, look, when the Supreme Court hands down judgment, for whatever reason, don't approach it because they can't sit in review of their own judgment?
I think I've gone over this again, but let me just put it this way again. If the other cases are similar, if the facts in the other cases are similar to the facts in Bayelsa, they should expect the same result. I expect that counsel in all the other cases will sit down with their clients, look at the outcome of the Bayelsa judgment, and ask themselves that pertinent question. Are there any genuine distinguishing features in our case that will warrant the Supreme Court taking a different stand from it? If it not, of course, they would be able to advise themselves that they were going to suffer the same fate But again, talking about the future, once we give judgment, don't approach us. That is not a position which the Supreme Court themselves have articulated in a lot of their judgments. What they have said is there is a limited room for reviewing their cases, and if the judgment did not reflect the reliefs given did not reflect the substance of the judgment, then we can intervene. And in one case, in fact, it was the case in Benue, Jeff and someone, where what happened was that it was a pre-election matter. At the end of the judgment of the Supreme Court then decided that, look, go back for rerun, or supplementary elections as they call it, rerun elections. The party that won, the appellant that won, went back to the Supreme Court and said, no, the appropriate relief that you ought to have given us is to return us to office. The Supreme Court heard that application and actually reviewed its judgment and returned that party to office. So there's a precedent to say the Supreme Court can, there's a precedent that the Supreme Court can endorse, review its case, but it's within a very narrow window. And I've already explained that narrow window includes where judgment is obtained by fraud, judgment is nullity, judgment is obtained by deceit practiced upon the court or upon the parties, where there are procedural steps taken which deprives the judgment of the quality of adjudication. So those are the limited circumstances in which the Supreme Court would review its case. And I think that remains true of the law. And let me use this opportunity to emphasize the importance of the legal profession. You know, that is why in the superior courts of record, no one is allowed to represent a litigant except the legal practitioner. The legal practitioner has two weapons or two equipments in carrying out that exercise. Number one is that he's a very well-trained person. Okay, so he knows what the Supreme Court has decided in several of these cases and in these instances. So he needs to bring that skill into making a judgment on whether the client should go to the approach the Supreme Court for a review. The other thing is that the legal practitioner is also bound by ethical considerations. You don't just take a case because you want to take money from it. If you take a case which constitutes an abuse of court process, you can be sanctioned not only by the imposition of fine, you can even be sanctioned by being referred to the disciplinary committee of the legal practitioners of the body of benchers, which is the body which deals with the disciplinary matters involving members of the legal profession.
So in this particular case, because speaking about that disciplinary procedure, do you think that that should kick in now?
That's a hard one. Number one, I think that the matter should rest at the point where, since the Supreme Court already chosen its own sanctions, the Supreme Court, one of the powers vested in the Supreme Court is the power to discipline counsel who appears before them. So if they have chosen the sanction of imposing this punitive cost, I think that's sufficient for in the circumstance of this case, and that should be a sufficient deterrent to any other counsel who may wish to tread the path which the Supreme Court has roundly condemned.
Speaking on the same issue of discipline for legal practitioners, so the Supreme Court has handed down this deterrence, just as you have said. But do you see it as sufficient deterrence, given that such cases stall other cases over the years, as many cases you would know, of course, that have been in the Supreme Court, that has been at various levels of the judicial process for many years, but we have to give urgency to electoral matters because of the urgency and because of the laws that surround them. Don't you think that the legal practitioners should be made to see that, look, these cases ought not to go beyond this place? Just as the Supreme Court said, there must be an end to litigation.
You know, even in the disciplinary process of the legal profession, there are graduation of punishments there is admonition, there is a suspension, there is striking off from the role of the legal practitioner. So it is not to be assumed that even if you took this through the process of discipline, the sanction is going to be that of the ultimate sanction, which is striking off from the role of the bar. Now, the point I'm trying to emphasize is that each of those measures is meant to send a deterrent message to the profession that this is conduct which is not acceptable. And my contention, my submission in this situation is that what the Supreme Court has done in punishing the counsel with that kind of hefty cost, it itself a very credible and very effective deterrent to other counsel who may want to tread that path in the future. And I think that the matter should rest at that point. That would be my view.
Just wondering, do you think that politicians will learn, though? Because almost every single case we have seen up for review now have been political matters. And some people will say that the lawyers have been egged on by the politicians. Does this judgment hold any implication for some of the agitations?
I think so. I think it does. I just mentioned here that I think that any of the applications pending at the moment, if I were counsel to any of those parties, I would need to sit down with my clients and look at the judgment in Bayelsa State and advise them. And if they don't want to take my advice, if I think that this is not a matter which I should pursue in the light of the judgment in Bayelsa State, the option is for me to withdraw from the proceedings and let him get some other lawyer. If he agrees, then you go and withdraw the matter, and that ends the matter. So definitely, this is going to have a lot of impact on the other pending cases because, like I said, very few of us as practitioners can afford to go to court and lose 10 million naira in cost, or in some cases even 20 million. That's a hefty amount of money, and I don't think any lawyer would want to. And I can assure you that the lawyers representing the parties who won that cost are going to enforce it. So if you had built a little house, which you were hoping to stay with your family, to be exposed to the challenge of having that house sold, if you can't raise the cash to pay, and it's not even likely to me that, because this costs against counsel, the politician that he represented may not even lift a hand to assist him. Well, so the counsel would be wise to realize that there is a very personal consequence on him if he takes an application before the Supreme Court, which the Supreme Court has clearly frowned against and disapproved.
We have to thank you for sharing your thoughts with us this morning. Chief of Young is a senior advocate of Nigeria. Thank you for coming on Sunrise Daily.
Thank you for having me.